The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit, are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
Please be seated. All right, we're prepared to take on our first case, and Mr. Fulton, whenever you're ready, sir, we'd be pleased to hear from you.
Thank you. Good morning, Your Honors. May it please the court. We have reserved 5 minutes for rebuttal. My name is Ross Fulton. I represent Malcolm Weiner, who was awarded $8 million in damages by a jury for Axe's negligence. When we were here 2 years ago in this matter before this court, the opinion in Weiner 1 reversed the district court's post-verdict subject matter jurisdiction dismissal, finding choice of law was waivable and waived. Weiner 1 remanded for a decision on Axe's challenge to the amount of damages, which was neither raised nor briefed in Weiner 1. Importantly, Weiner 1...
We reversed, but we did leave the matter of damages to the trial court on remand.
Yes, Your Honor. Yes, Your Honor. Remanded on the issue of damages, the amount of damages. But in the opinion in Weiner 1, this court also rejected Axe's alternative arguments based on the sufficiency of the evidence of Weiner's injury and causation, finding, quote, ample evidence, quote, close quote, to support the jury's verdict, citing testimony that Axe was negligent in falsely reporting to the MIB clearinghouse that Weiner suffered from 4 serious medical conditions that he did not have, and that Weiner became effectively uninsurable or uninsurable at a reasonable cost as a result of that negligence. This court found that Sanford Robbins, Mr. Weiner's insurance broker with 37 years of experience, testified he was unable to find a $16 million replacement policy at the standard rate. That Mr. Robbins testified a healthy person of Mr. Weiner's age would obtain a standard rate insurance. This court cited testimony that 6 carriers declined coverage altogether, 2 made preliminary offers of a $10 million policy at double the standard rate, and that Mr. Burgess, citing his testimony, the underwriting and damages expert proffered by Mr. Weiner at the trial, testified that life insurers look at MIB codes early and would be deterred from starting the process for someone with significant MIB codes on their record. Mr. Burgess also testified that at least one MIB code submitted for Mr. Weiner was a deal killer and a hot button issue that would prevent insurers from issuing policies to Mr. Weiner. Mr. Robbins testified that he was told by an insurer that MIB codes presented an underwriting problem that would prevent the issuance of a standard rate policy to Mr. Weiner. These findings from Weiner 1 are the law of the case. On remand...
Can you help me understand why they relate to damages? I'm totally tracking everything you've said, but maybe I'm just missing something. You seem to focus on these a lot in the brief too. What do they have to do with damages?
What it has to do with damages, Your Honor, is that Mr. Robbins cited the amount of the standard rate policy premiums that would cost $400,000 per $10 million in insurance. There was citation to the amount of the replacement policy that Mr. Weiner was seeking but was unable to obtain as a result of Axe's negligence, which was $16 million, so 1.6 times that amount. So the jury had in their hands the amount of the policy that he was seeking to obtain but was unable to obtain as a result of their negligence, except at an unreasonable double the standard rate, perhaps, rate. They had the amount of the premiums. They had the double the amount of the premiums that it would cost. And so the jury was able to go back and do the math necessary to come to its very reasonable $8 million conclusion.
So accepting your premise that we're looking at 8, not 16, I think that's wrong, but I'll accept it for a second. Tell me how that reasonable math happens and maybe focus a little bit on how there was evidence to support 12.5 years of life expectancy?
Yes, Your Honor. So first, we don't know exactly what the jury did, which is...
No, but what we know is they can't pick numbers out of the air, right? They can't literally just make a number up. right? That's
Correct,
that's
yeah.
the whole point of the law of like damages. It can't be totally and completely speculative.
Correct, Your Honor. It can't be completely speculative. It has to be at least reasonable. And here, we believe the jury did act reasonably in coming to its $8 million conclusion, in starting from the $16 million policy that was being sought, which we've cited cases in our brief that the face amount of the insurance policy can be a reasonable maximum amount of damages for the loss of an insurance policy. And then, working their way down from there, it was accepted, unrebutted testimony of the expert witness, Stephen Burgess, that the amount of damages would be the $16 million in policy premiums sought as a replacement policy, less the premiums that would be paid on that policy moving forward. The amount of those premiums were known to the jury.
Where is that in the JA?
Yes, Your Honor. Mr. Burgess's testimony on that was at, I don't have the JA site, but I have the trial transcript site to pages 328 and 329 of the trial transcript.
So he said it is 16 minus the premiums to be paid, and you agree that's right?
We agree that's right, Your
Okay,
Honor.
all
And
right, so how did he tell us to calculate the premiums to be paid?
And so here's where the trial transcript takes an interesting turn, because, and this is why I believe $8 million is the correct number of the research.
Okay, but tell me where, you get to the
Yes.
answer, and then you can explain it.
Sure.
Where does the 12.5 come from, other than like a Ouija board or something?
At this point, Mr. Weiner had already lived 6 years since the denial of the premiums at the time of the trial. And so he had,
But that's not a relevant question. The question is, what was his life expectancy in 14? Right? The question that has to be asked by the jury is, what was the damages at the time?
correct.
Right? Which requires a probability distribution of his likelihood of death in each year to follow. Right? That's what they needed to do. And the fact that he happened to live 6 years is irrelevant to his actual damages, because you had to look at the life expectancy probability distribution in 14,
And
not
he-
in 20 when we happened to be there.
Yes, Your Honor, but here we have a 79-year-old plaintiff at the time of the event in 2014, Mr. Weiner. The jury had in front of them ample testimony, both from Mr. Weiner and from his primary care physician, Barry Boyd, about his health both at the time in 2014 and at the time of the trial. They had evidence of his health.
But you agree, his health at the time of the trial doesn't matter. It's his health in 2014. Because you have to, the damages are as of that day, right? It doesn't, the fact that he's alive in 2020 is like true, but it doesn't affect what his damages were in 2014 in any way.
Under North Carolina law, Your Honor, the jury can make a determination of life expectancy based upon the health, the constitution, the practices, the patterns of.
What is the North Carolina law that says, with no testimony from any actuarial information, no testimony from an expert about life expectancy, that the jury can just pick a number as to how long they think a given 79-year-old person, is going to live?
Your Honor, we would cite to Wooten versus Warren by Gilmer, which is 117 North Carolina Appellate 350, 1994, which discusses that the health, constitution, habits, and the like can be relevant evidence that a jury can rely upon in coming up with
They
life
can
expectancy.
be relevant evidence, but the jury can't look at a 79-year-old man and estimate how long he's going to live without some evidence.
The evidence here was testimony from his primary care physician of over 25 years about his checkups, his practices, about his habits, about his lack of diagnoses of any condition that would affect his life expectancy at the time.
And I'll stop, and I'll let my colleagues, but in your testimony is based on that, the doctor saying he's been coming in, he seemed like he's fine, that the jury could conclude that in 2014, 6 years earlier, his life expectancy was 12.5 years, and that would be a rational decision based on evidence.
Yes, Your Honor, as well as Mr. Weiner's testimony himself about his health and his practices, which was the subject of his testimony, which the jury could then see and judge for themselves and decide upon whether they agreed with him or believed him about his health and his constitution and his practices. And here I'd like to go back to
On the expert testimony here, the opposing side indicates that the expert spoke only in the most general of terms, and that the expert lacked any firsthand knowledge of Weiner's actual situation, or also his effort to replace the coverage. In other words, the expert testimony, your opponents say, was simply insufficient to rescue the jury damages award from being purely speculative. What do you do with that, given the fact that the expert spoke only in the most general terms and was unable to, and you don't want an expert to become a fact witness, but he didn't have any knowledge of your client's situation, and so his testimony isn't enough to predicate the damages award, is it?
Your Honor, his testimony is supported by the testimony of Sandy Robbins, that what Mr. Weiner was attempting to do was find replacement insurance for the $16 million policy that he had lost. And when Mr. Burgess appears and testifies that $16 million was the number, and he is their expert on damages, we believe that combined with those two factors, in the light most favorable to Mr. Weiner, the jury could reasonably rely upon that testimony. I did want to touch upon an issue regarding the $16 million versus $8 million number at JA 1135. During Mr. Burgess's testimony, there was an objection by AXA to him continuing to testify about the premiums that would be paid on the $16 million policy.
Can it be said that the real damage award that the jury came up with, and the one that you need to justify, is the 16 million rather than the 8 million, because the 8 million represented a mitigation effort, but it didn't actually figure into the damage award? Isn't the figure that you need to justify in terms of the reasonable certainty standard the 16 million?
Your Honor, we believe it's the 8 million, and it's in the cases that we've cited.
Why is it 8 million, given the fact that the 8 million seems to be predicated purely on a mitigation?
And again, Your Honor, at JA 1135, during the objections to Mr. Burgess's expert testimony about the future premiums.
But how about answer that question, right? Because you said the cases, but you give us no case where you have a special verdict form and you have two separate steps of damages, and that the court is supposed to ignore the first one and only look at the ultimate conclusion. The cases you've given us don't say that at all, by any stretch of imagination. And all the cases we have say, when we have a special verdict form, we look at each answer, right? Not that we just look at guilty at the end of it or the total damages. If you give a special verdict form, we have to justify each aspect of the verdict.
And yes, Your Honor, but, and again, just getting to this point very quickly, that, and those objections to Mr. Burgess's testimony, it was characterized by the counsel in arguing with the court that the testimony about the future premiums was being offered in terms of mitigation of damages, and the court invited AXA, accepted that characterization, and invited AXA to ask about it on cross.
So it is true that you said it was mitigation, right? But that does not make it mitigation, right? Like, the fact that you, and I don't necessarily mean you personally, but your side said this is mitigation, doesn't actually make it mitigation, right? I mean, it doesn't fit under the instructions. It's like a nonsensical idea to think that the premiums that he would have paid had he gotten a policy is somehow mitigation.
Your Honor, what we contend is that it's reasonable for the jury to consider that under the mitigation line when the court and counsel acted and characterized the future premiums as mitigation during the course of the trial. If court and counsel are treating it as mitigation during the course of the trial and the jury is there, we believe it's reasonable for the jury to also treat it as mitigation.
So in contrast to the jury instructions, you think the jury should have relied on your lawyer's claim that it's relevant to mitigation and the overruling of the objection, that they should have figured out from the overruling of your colleague's objection that that should govern instead of the jury instructions?
Your Honor, it was sustaining Axe's objection, but in doing so, we believe that the court was accepting the characterization that these were being offered
And the jury was
mitigation
supposed to
damages.
understand that that overruled the jury instructions that were given to it. That's the argument, that they should have listened to the objection response and not the jury instructions.
Your Honor, I see that I'm out of time. Would you like me to?
I think Judge Wilkinson will let you answer the question.
Go ahead. I just had a brief question. However we characterize the 8 million as mitigation or something else, how would that relieve us from the inquiry of whether the 16 million, that figure, was proven with reasonable certainty? We still have to answer the question with regard to the 16 million, do we not?
And Your Honor, we believe the 16 million was a reasonable starting point based upon the cases we've cited, that is a maximum amount for the loss of a insurance policy. And Your Honor, we do believe that the characterization in court in front of the jury that these were for mitigation of damages would make it reasonable for the jury to have done that math on the form in the manner that they did in finding their ultimate conclusion of damages of $8 million.
With the Chief's lead judge permission.
Go
this
ahead.
question? Thank
Sure.
you. Mr. Fulton, you know, obviously you chose to litigate this case because you're the plaintiff, and you chose to seek damages based on rendering him uninsurable or at least insurable at an unreasonable amount. You chose, following up with my dear colleague Judge Richardson's question about what happened at 2014, you didn't ask for the value loss, did you? Because you could, in other words, the question could have been, what is the value of a $16 million insurance that you've put $3 million in over 26 years? What is the present day value of that? You didn't, that wasn't your theory, was it?
No, Your Honor. It related to the inability to replace that insurance policy.
All right, so then you're left then with, then your case would have been then exactly how much that would cost, right?
Right.
Did you tell the jury what it would cost? I mean, that cost along the $400,000, that was, right?
The $400,000 doubled.
Doubled, that was your
Correct.
theory, right?
Yes.
Basically, in other words, rather than, to me, this should be a case of specific performance, that is, and no, I won't say that. But the question is to put him back where he was, and that is a $16 million policy at a premium, and whatever that premium is above what's unreasonable would be your damage, because you have to pay premiums. Did you put that case before the jury, you think?
No, what we put in front of the jury and the evidence relating to what happened with the original lapsed policy was excluded by the court in this case because it was the subject of a companion case, I guess I will call it, related case in New York.
Do you have further questions?
That's all.
All right, thank you very much.
Thank you, Your Honors.
All right, let's hear from Mr. Sarchak. Is it possible that if the $16 million is not justified or cannot be proven, does that mean we automatically go to $1 of nominal damages? Or is there some in-between number that might be ascertained in a retrial on the grounds that the result of the first trial was against the weight of the evidence?
The district court did make an alternative grant of a new trial, and there would obviously be discussions on remand with the district court about the scope of that retrial and how much Mr. Weiner might expand on the evidence presented in the 2020 trial. But in the 2020 trial, which is this morning's focus, there were two key failures of proof. And
But I'm saying, could the failure of proof be corrected on a new trial?
if
new
the
trial.
district, I'm sorry, Your Honor.
Could it be corrected in a new trial?
If the district court allows Mr. Weiner to go beyond the evidence he presented in the first trial, he might be able to cure these problems, but some of the problems are ones that call for expert testimony, and that expert testimony wasn't presented here. So the two key failures of proof.
Can you help me just in a procedural question to make sure I understand your position? Your position is because there was a judgment entered here, what we're reviewing is the question of whether nominal damages was improper.
Whether the,
Because the district court awarded, maybe I'm just misremembering, the district court awarded nominal damages here.
correct, in fulfillment of Rule 50.
Right. And so we would have to find that that was an error to get to the alternative ruling that a new trial, or those are alternative grounds that we can reach.
I agree, it is an alternative grant under 50C1, so the new trial arises only if the Rule 50 grant is reversed. So I'd like to focus on the
Only if the district court was in error.
on the Rule 50B, or the ruling about damages on remand specifically. So the two key failures of proof I'd like to highlight are, number one, the size of policy or death benefit that Mr. Weiner could have gotten if not for the MIB codes. No witness testified to that. My friend argues that if not for the codes, Mr. Weiner could have gotten a $16 million policy. But no witness said that. Either Mr. Robbins or Mr. Burgess, had they had a basis, perhaps could have said that, but neither one did. Secondly, what would have been the premiums that would have been paid on a new policy?
But your position at bottom is relatively simple, and that is, or straightforward, and that is that Mr. Weiner bore the burden of proof with regard to damages, and that he had to prove the damage award with reasonable certainty, and that given some of the difficulties you've enumerated, he did not carry his burden of proving the damage award with reasonable certainty.
That's right, Your Honor.
I mean, that's what it comes down to ultimately.
Yes, and the specific aspect of the proof of damages that wasn't proved with reasonable certainty was the but-for scenario. If the MIB codes had not been in place, what size policy, what premiums would have occurred? The state Supreme Court in North Carolina's opinion in Lee versus Meyer speaks right to this. That was a case in which there was an auto collision, injury was proved, but there was no showing of what the condition of Mrs. Lieb's car was before the crash, what its value was, and the like. That's very similar to the circumstances here, where part of the burden Your Honor has identified to show damages with reasonable certainty is to show a baseline. And that was exactly Judge Conrad's ruling, was that there was no baseline. And he particularly focused on the lack of a baseline on the amount, the death benefit of the policy.
Well, I guess the part of the problem is this is life insurance. And you're dealing with a 79-year-old individual. And the replacement policies, such as they are going to require a substantially higher premium. And I guess the only concrete evidence you have is that the insurers that were willing to insure this were only willing to do so at a rate that's far greater than a standard rate. Is that right?
That is right, Your Honor, and a key premise Mr. Weiner offers here is, again, on the but-for issue, is that in the absence of the MIB codes, he would have qualified for the standard rate. No witness said that. Your Honor?
No, go ahead.
All Mr. Robbins did on page 928 of the joint appendix is to define the standard rate. And it would have been very easy for him to go ahead and say, if not for the codes, Mr. Weiner would have qualified for the standard rate. But neither he nor Mr. Burgess said that.
Did you use the MIB codes to, in fact, your decision not to reinstate his policy after the lapse?
Did Equitable rely on them, is your question, Your Honor?
Yes.
No, because the MIB codes were issued in connection with that denial of reinstatement. In other words, they were not pre-existing before Mr. Weiner applied for reinstatement in the 2013.
So in that process, you didn't use any of that misinformation to inform your decision to deny reinstatement, is that right?
That's right, Your Honor, because the MIB codes were actually issued in connection with the denial of reinstatement.
So this coding was just totally after you had made your decision? Totally?
Yes, I'm not entirely clear on the timing, but they were definitely connected with each other. And Mr. Weiner's theory of the case is that it is those codes that made him effectively uninsurable, and that was this court's holding before. That covers causation, that covers injury, but what the court remanded for is quantification of damages, or specifically testing.
Your view is that it bottoms out on a question of causation.
No, Your Honor. It bottoms out on a question of causation. Strike that. It bottoms out on quantification of damages that this court held in the last opinion, that there had been a cause of the injury of effective uninsurability, but what are the damages for that?
Right, causation is established as the law of the case when you went back, right?
Yes, causation of his injury.
So all we have to do is the quantity. Well, isn't there evidence that it would be $400,000 for the premiums and those type things that are there?
Yes, but that assumes a premise that wasn't established by the evidence, which is that premise being that in the absence of the codes.
That's a causation premise. Causation is established. The question is quantifying it. And the quantification is the premiums that he has to pay over and above. So you're bleeding back into it. The causation is established, the law of the case.
Your Honor, I think the Lieb decision might say differently. In Lieb, the court found causation, found the fact of injury, but said the inability of Mrs. Lieb to establish the baseline of what her change in value of the car was a damages problem. The court ended up.
Can I ask what maybe is a related question, but maybe is not? So, back up a little bit at a higher level of generality. Wouldn't the net present value of life insurance, if anybody who's getting a new life insurance policy today, the net present value of that has to be less than zero. Otherwise the insurance company wouldn't issue it, right? There might be other benefits, risk aversion and the like, why I buy it, but I don't buy it because the net present value is positive, right? The money I put in, expected money I put in, can't be less than the expected money I'm going to get out, taking into account my life expectancy.
Right, and
Right.
that's.
Taking into account, but And so I guess I have a little hard time understanding how the basic theory here works. If I understand the New York action, and that's very different because he had paid $3 million in over a long time and there are real damages there. But I don't understand how a new policy under any scenario could create the kind of economic damages we're talking about. By definition, right, its net present value is less than zero.
Your Honor, I think to say by definition might be too strong because there are assumptions that would have to be made.
Right,
that
the
might-
insurance company, you're right, the insurance company, who's the expert on this, could be wrong, right? Or they could be trying to lose money, right? I guess those are two premises. But if we accepted actuarial tables, and maybe we shouldn't, but if we accepted them as broadly accurate, and we accept that the insurance company is doing its level best to make money, the net present value of the policy has to be less than zero. And I get those are two assumptions, but taking those two assumptions.
If the insurance company is accurate in the reasoning, what the Garland case from the state Supreme Court says is in a situation of uninsurability, which was the case there, the proper measure of damages is the just value of the policy not available to the insured. That's where Mr. Wiener is arguing for this idea of the
Right,
death.
but I guess what I'm asking you is, the just value, from a pure economic perspective, the just value is zero. That doesn't mean its actual value is zero, because it provides some comfort that my family will be taken care of, right? It spreads out the risk that I might, die at an early age where I haven't made enough money, all these sorts of things, right? There's value to it, but there's not the kind of economic value that we're talking about.
Suffice it to say that the state Supreme Court in Garland and the other opinions the parties are citing don't get down to that level of economic analysis. What Garland says is take the death benefit, subtract the expected premiums over the lifetime of the insured, and that's the just value. And in footnotes 7 and 8 of my colleague's brief, they adopt that. And the problem for damages here is that the really three key building blocks, as Your Honor has said, are missing. Number one, what would have been the policy in the but-for scenario, the death benefit. Second, what would have been the premiums in that scenario. And third, what would have been the life expectancy. Not one of those points was shown in the 2020 trial in this case. Instead, I'd really highlight Mr. Burgess's testimony on damages on page 1134 of the appendix. Far from arguing for a measure of damages like the one we're discussing so far, he simply said he had a policy with Equitable before, Equitable didn't reinstate it, so he was out the $16 million of death benefit. And then in closing, Mr. Wiener's counsel said, Burgess told you straight. So,
And you don't disagree with that because, and I'm not trying to ask you to concede in the New York action, but in the New York action, this same measure of damages might yield a positive net present value because he's been paying premiums for 20 years, right?
Yeah.
If they wrongly, if they should have reinstated or renewed the policy, I'm not taking a position on it, but had they done so, there might have been a net present value that was positive in that instance, but there's not a net present value that's positive in any new policy.
Your Honor, on the suppositions that we've discussed,
Yeah.
that's probably right.
But that wasn't argued in this case at all, was it?
No, for the reason I just said, Your
Right.
Honor, which is that.
Exactly, because in other words, I understand what my friend Judge Richardson is saying, but if that's the case, then you could have all kinds of violations with impunity. He said, well, we could do anything we want to do, not hypothetically, of course your company wouldn't do that, but any other company would, but say, well, we did this and we put all kind of codes in, but you don't have any damages because, it's going out to get a new policy has no value. I mean, so it has to have some value to it, and it seemed to me, what they're trying to say is that this is what I had to pay additional premiums trying to get a $16 million policy. And when that should have been calculated, I'm not sure. That's what we have to, we're trying to get help with that. But say it's nominal, it's only nominal, it's no value at all, having established causation, and say there's no damages at all. It's,
Your Honor, it's not necessarily that an omniscient narrator would have come in and said Mr. Weiner had no damages, but Rule 50 looks to the evidence that was presented. And for whatever reason, Mr. Weiner made the choice to discuss this measure of damages based on the earlier policies. That's one problem, and that's one point that was discussed by Judge Conrad in his opinion. Here in this court, we've gone beyond that in the briefing, and the parties are discussing two alternative measures of damages as part of Mr. Weiner's effort to shore up the verdict. One of which is this notion of net policy value that we're discussing. The other one is a premium delta. Both of those measures of damages are missing a baseline. That was Judge Conrad's point, is what was that but-for death benefit? What was that but-for premium? And neither Mr. Burgess nor Mr. Robbins nor any other witness spoke to those issues. Mr. Weiner is assuming a $16 million death benefit. He is assuming eligibility for the standard rate.
why do you say he's assuming it? That's what he had. He had a $16 million death benefit. He had a calculable premium rate that he was paying. Those established. The question is, what would it cost him above and beyond that to get where he was? Maybe and that's the whole point, maybe nobody would have done it for any reason, but that's part of the calculus. Now he's back into a market that you forced him into, which was established because of the causation. You put him in this market. It's very difficult for an older person to do that. But that's what you're trying to establish. How much more do I have to pay in a premium to try to get back to the death benefit? I mean, it's not rocket science, but it is something that has to be carefully done. But that's what you're trying to get to. It's not speculative as the 16 million in terms of the goal, nor a premium, which he was already paying. So if that's the flat line, what's the up to the premium to get there? And the fact that he can't get there because he's uninsurable, nobody would do it, you may be right. Maybe if there was no miscalculation of the MIB, no one would do it, but that's part of his damages, isn't it? Because you put him into that market.
Your Honor, no, that wouldn't be part of his damages because that's the theory of the New York case.
Well, we can't try the New York case, can we?
I'm sorry, Your Honor?
We can't try the New York case.
No, certainly
That's
not.
before us, but so that's your business. What happens there, I have no concern with that. The
I'm
case
sorry.
is here, this case.
Yes.
What they were trying to do here is to show what the escalation of the premium was to try to get to the 16 million.
Right, Your Honor, but the world in 2014 was the MIB codes were in place. So under Lieb, to decide the incremental damages from the existence of the MIB code, there had to be a baseline established. Judge Conrad said specifically in his 5059 order on damages, the terms of the 1986 policies are the wrong comparator because at the time, those policies lapsed for non-payment of premiums. So
He was not the trier of fact, was he?
no, he wasn't, but he was assessing the sufficiency of the evidence on damages as instructed by this court in 2014. One last thought, Your Honor, which is my friend has said Mr. Weiner would have qualified for the standard rate because he testified to his health. That's not the question on what rate he would have qualified for. And what Judge Conrad said in the remand hearing was one's own self-assessment of health, that might not be at all what insurers would say. No one, specifically the question is, what is the level of health for a 79-year-old person to qualify for the standard rate? No one said that Mr. Weiner's health were sufficient. So, Your Honors, for these reasons, as well as what's in the briefing, we'd ask the court to affirm Judge Conrad's Rule 50 and Rule 59 conclusions on damages.
Thank you.
Thank you,
Do
Your
you have any
Honors.
more questions? All right. Thank you. Mr. Fulton, you have some rebuttal time.
Thank you, Your Honor. I think we agree with Judge Gregory that really AXA's argument returns to arguing about causation. Page 16, the full paragraph on page 16 of this court's opinion in Wiener 1 is that Wiener presented evidence that he became effectively uninsurable. Robbins testified about his unsuccessful efforts to obtain a replacement $16 million policy for Wiener at the standard rate, which is the rate the typical person would obtain if they were healthy. Two insurance companies made preliminary revocable offers for a $10 million policy at double the standard rate, which would have cost Wiener an extra $400,000 per year. The jury could properly have concluded from this evidence that Wiener had become effectively uninsurable or uninsurable at a reasonable cost. And we would posit that that same testimony would allow the jury to reasonably calculate the damages that came from that uninsurability. And that AXA,
But you agree that that paragraph doesn't answer the last question you just put, right? So it addressed causation. I totally get it, right? But it didn't address damages. The court was very clear. We are not addressing damages. And so, I mean, I understand you keep saying that, and maybe I'm just missing why you think that resolves damages when the court said it does not resolve damages. You might have arguments that you can prevail on damages. I totally understand. But I don't understand why you keep going to that language. And I just want to make sure I understand it. So
Sure.
help me.
yes, Your Honor, it's our position that the jury can take that same data, the $400,000 premiums per $10 million in life insurance, the double rate this versus the standard rate, and the $16 million policy, replacement policy that was being sought, and could go back and could do the math that allowed it to come out with this $8 million conclusion.
Using a life expectancy probability distribution that comes from where?
That comes from the jury's observation of Mr. Wiener's testimony, his testimony about his health, his doctor's testimony, 5 years of medical records they had access to that were an exhibit in the trial and are in the joint appendix. They had.
But there, all of that information is like after 2014, which is the relevant date, right? The damages are as of 2014, not 2020, right? I don't understand how any of that evidence is even remotely relevant. Like, if you had records from 2013, I totally understand their relevance. I don't understand the relevance at all of anything that happens after 14.
I'm sorry, Your Honor, just to clarify that, the 5 years of medical records were for the period leading up to the decision in 2014, the purpose being to show that he did not have the medical conditions that AXA in 2014 told the MIB that he did have. And so that
Which was the negligence piece.
Which is the negligence piece, but it also goes to his health at the time in 2014. At the time of the
And
negligence.
from those records, the jury was supposed to conclude that he would live 12.5 years.
The jury could reasonably conclude that he could have lived for that period of time based upon their observations of him, their medical records, the testimony of the doctor about what was happening at the time in 2014, that AXA negligently and falsely reported that he had conditions that he did not have. Your Honor, just to address the $16 million single policy that AXA refers to, a replacement policy, is a red herring. The original policies that lapsed, there were 3 separate policies that added up to $16 million. So the fact that there's not a single $16 million policy that was applied for is not remarkable here. Mr. Wiener was seeking to replace that life insurance and had multiple applications out there for large policies. With regard to Your Honor's comment about the net present value of an insurance policy being less than 0, multiple courts have found life insurance policies to be assets that have value to someone who loses them. And
They totally do, right? And so when you look at cases that address it, but they're policies that were pre-existing. So the New York policy, the policy that was canceled, plainly has a positive, or at least plausibly has a positive net present value. But a new policy does not. And I found no case that says a new life insurance policy has a positive net present value.
well, Your Honor, insurance companies also make money from investing the premiums today and paying out benefits tomorrow in the future. And so it's not a one-for-one exchange of I'm immediately at a loss by paying you premiums in month one for an insurance policy that has a death benefit. Because despite what the actuarial tables say, I could get hit by a bus out on the street and I could end up in a positive value situation.
But we understand expected value is not that, right? Expected value looks at the probability of an event times its cost, right? So yes, it is true you could die in year one, but we don't calculate the expected value of a contract based on like a probability of 1%.
And Your Honor, I see that I'm out of time. I don't know if the
Go
panel.
ahead if you want to answer Judge Richardson's question.
No, thank you, Your Honor. Your Honor, again, I think that because life insurance policies do have value per courts, and I think that insurance companies aren't selling something assuming that only the premiums are going to make them money. It's also the investing of those premiums over time that an insurance policy can be a win-win situation even at the beginning of the policy for both the holder, the policy holder, and the insurance company.
All right, we thank you. We will come down and greet counsel, and then we will move into our next case. Mr. Farrell?
Thank you, Your Honor. My name is Cliff Farrell, representing Ms. Drummond, and I do ask for 3 minutes for rebuttal. Ms. Drummond filed her application for benefits in the current application in 2020. Prior to that time, she had worked, she'd been in the military for 4 years and then worked for Social Security herself. And the record reflects that she'd had depression problems going back at least to 2010. But something happened at her alleged onset date her amended onset date, and she snapped and left work. She'd had problems with PTSD and depression. There's no question about the severity of the problems. She'd also had physical problems, which the judge considered. The time of the hearing, she was 50 years old, and her described testimony at the hearing was basically she didn't do much. It was a video hearing. She could cook, but usually what she did was make a sandwich or have a simple meal. The household chores, the activities of daily living, the things that normally get done, either her 2 children who were ages at that point in time 16 and 17, or her husband did them. There were days she didn't get up. There were days she got up and watched TV. Maybe once or twice a week she'd go to get medications. Basically, parenting activities were all deferred to her husband, and all she could do was try and stay basically isolated. During that time from at least 2010, she'd had regular counseling and therapy. In 2015, she changed therapists in the same practice and started seeing Ms. Samadi, who is the therapist whose opinions are part of what are at issue here. Ms. Samadi saw her on a weekly, bi-weekly basis, sometimes as needed. In the 6 years between October of 2015 and October of 21, the timeframes in which she was discussing in her narrative reports, that would have meant a minimum of 70 to 100, maybe as many as 150 times she'd had an interaction with her. She provided the letters and assessments that appear in the record, joint appendixes, pages 511, 559, 560, 565. Ultimately, Social Security decided to send this claimant out, Ms. Drummond out for another evaluation, and that doctor wrote a great report from my perspective. Explained what he observed, what was going on, how she reacted. She appeared tearful, she was difficult, was disheveled in appearance, things that you don't normally see very often in a Social Security case. The hearing judge rejected the assessments of both the consultant and the treating therapist. Excuse me. I'm not a big fan of the language of not entirely consistent with the medical and other evidence in the record. But that's the decision. I think that Arrakis questions the reliability of that. In this case, we have a therapist who provided identified limitations. We have a consultant for Social Security who, in some regards, provided even more significant degrees of limitation. And then, in order to work around them, I think the judge made a false equivalency. Excuse
Why
me.
isn't this just an evidentiary question, weighing the testimony of Dr. Samardi, who is the plaintiff's main witness, against Dr. Luther, who painted a substantially different picture and listed the kinds of activities she could engage in, and the ALJ says, I guess the ALJ says, I'm going to credit Dr. Luther because Dr. Samardi's testimony was thin, and there was no supplemental information that was necessary, and particularly as respects the sort of longitudinal progression or lack thereof over the course of a number of years of therapy. So I'm wondering, why does this case involve anything more than a question of an ALJ crediting one witness and not another?
Because the standards of evaluating supportability and consistency require the evaluation of those records and those reports. Dr. Luther saw the claimant far less, and even in her records, there was only one time where I was able to find that she thought things were well controlled. The rest of the time, she always referred to her mood as being euthymic. Doesn't mean she's got a normal mood. It means that her mood is at a plateau between her manic phases and her depressive phases. So even Dr. Luther is supporting, and Dr. Luther is really not treating her. All she's doing is for the mental health. All she was doing was prescribing medications because the therapist, Samardi, couldn't prescribe the medications. So she notes that, Ms. Luther notes that there are problems of time where the
Have we ever
client...
said that a doctor prescribing medications to somebody is not a treating physician? And that seems like an odd, I've
No,
not heard that line before, right? To say that the doctor was not treating her because she was only providing the medications that were necessary to treat her? I guess I just don't understand the argument that the doctor's not a treating doctor when they're the ones
She's
prescribing.
clearly was a treating physician, but was not performing the intensive psychological evaluations or the psychiatric therapy. That was being left to the therapist. The reasons could be financial, I don't know. But
Was the allegation,
So she's-
was the allegation the doctor was like improperly prescribing
No.
drugs? Like
No, no,
hadn't
no,
done
no,
enough
no,
work to
no.
know whether to prescribe the
she
drugs or not?
was aware that the claimant was depressed and was prescribing her depression, and then would make notes. She made a few notes about her mood being euthymic. One time she noticed she was crying in the office. So she was aware of it enough to prescribe medication. But the primary treatment source was the therapist, Ms. Sarmati. And in fact, the psychologist who Social Security chose to examine her supported Ms. Sarmati. Based on his evaluation, the limitations that would have been described, or that were described, would have been work preclusive. She was the point where the consistency and the supportability is, and that the judge inadequately addressed, is she's not going to be able to make it through a normal day. She's not going to be able to make it through a normal week. She's going to have problems with her attendance. If you consider nothing else, just that one. There were a number of other limitations where they agreed were significant. And even if you look, the judge's decision says the mental status examination shows labile mood, dysphoric affect, disheveled appearance, tearful demeanor, below average working memory skills, moderately compromised, delayed recall, below average abstraction, insight, and compromised judgment. Those are what the judge finds are significantly limited and supported by the record, and that's Joint Appendix 31. And then the rejection of those is based on the fact that she was able to cooperate during a 1-hour examination with the doctor and had good eye contact and normal language. Well, the fact that she has normal language says nothing about whether she's going to be, I'm sorry, that last was Joint Appendix 32. The fact that she has normal language, or that she can make eye contact, has nothing to do with whether or not she can make it through an 8-hour day, 5-day a week. Job setting. I mean, this lady, at different points in the record, was never suicidal, but she was homicidal. I don't know many employers that would want somebody there that works that is in that kind of mood. And the Joint Appendix, all the medical...
I mean, we have these cases that bottom out on supportability and consistency. And I think the ALJ addressed both supportability and consistency, saying that Dr. Samardi, his opinion, her opinion was very thin, that it wasn't backed up, that there were conclusory statements that weren't backed up sufficiently by any kind of supporting information. And the whole purpose of the supportability prong of these inquiries is to get behind the conclusory statements. And the ALJ said that didn't happen here. They wanted an explanation other than just the statement of a conclusion. And then when you get to the consistency prong, you've got Dr. Luther's testimony, and he lists a good number of the daily tasks that the plaintiff here could perform. And what Dr. Luther said completely contradicted what the plaintiff's main witness was. So there's a consistency problem that Dr. Luther's testimony raises, and the supportability prong there's a difficulty there because you get these conclusions and they're just not backed up sufficiently by supporting evidence. So it wasn't as if the ALJ was clueless as to what needed to be proven or inquired into. And I mean, where's the reversible error?
I see my time has expired. If I may.
Would you mind addressing that on your rebuttal?
That would be fine, Your Honor. Thank you.
Okay, that would be good. All right, Ms. Wisniewski. Good.
Thank you, Your Honor, and may it please the court. My name is Carolyn Wisniewski, Assistant United States Attorney representing the Commissioner. The sole issue before the court this morning is the administrative law judge's evaluation of plaintiff's mental health impairments, specifically the ALJ's finding that the opinions of plaintiff's mental health counselor, Ms. Sarmati, were only partially as opposed to fully persuasive. Plaintiff claims that the ALJ did not properly evaluate Ms. Sarmati's opinions for consistency or supportability, the main factors an ALJ is required to address when evaluating medical opinions. However, this is incorrect. The ALJ's 21-page opinion gives a careful and considered evaluation of Ms. Sarmati's opinions and addressed both factors at length, comparing them with the record evidence before explaining why she found them to be only partially persuasive. Now, Fourth Circuit precedent dictates that only a logical bridge between the ALJ's conclusions and the record evidence is required. The ALJ here more than supplied such a bridge and did so based on substantial evidence in the record. As the ALJ explained, Ms. Sarmati merely checked several boxes on a form supplied by plaintiff's disability advocate that she had marked limitations in 2 areas of functioning due to her mental health conditions, which consisted primarily of depression, bipolar disorder, and PTSD. But during the relevant period, February 27, 2019 through the end of 2020, plaintiff's medical records tell an entirely different story. During the 22 months, plaintiff saw her primary care physician, Dr. Sylvia Luther, 6 times. That's about once every 3 or 4 months, and checked in several more times for refills on her medication. During this entire time, Dr. Luther diagnosed plaintiff's depression as in full remission. Indeed, plaintiff's depression merited only 1 mention in all of Dr. Luther's treatment notes, as opposed to the many times that plaintiff brought up other issues that were ailing her, such as her asthma and back and foot problems. And that was in August of 2020 when Dr. Luther recorded plaintiff as noting that she remains on Lexapro and feels it helps mood, although she is still bothered by thoughts of acting out against people, but, quote, consider these impulses to be out of character for her. Yet, even then, as on all other occasions, Dr. Luther reported plaintiff as having no anxiety and no depression, and that plaintiff had screened negative on testing for depression and PTSD. Now, plaintiff's treatment consisted of mostly medication, primarily Lexapro, and therapy with Ms. Sarmati that took place once or twice a month. In December of 2018, 2 months before plaintiff's onset period, Dr. Luther reported that plaintiff's depression was well controlled on current therapy and meds. Plaintiff takes issue with the ALJ's characterization of plaintiff's treatment as routine and conservative, but that's a fair description, given that plaintiff was on Lexapro, a very commonly prescribed drug for depression, and at the hearing testified she attended therapy only once a month. There's no evidence that plaintiff's symptoms or conditions were so severe as to require hospitalization, inpatient treatment, or a more serious medication such as a tranquilizer, antipsychotic, or mood stabilizer. And there's no indication here that plaintiff either requested or was referred to a psychiatrist. Simply put, there is nothing in Dr. Luther's ongoing treatment records that indicate that plaintiff had a severe mental health disorder that markedly limited her ability to function.
You don't think that bipolar is a severe DSM-3 diagnosis? You don't think that's a severe DSM-3 diagnosis for mental health?
No, I apologize, Your Honor, if I misspoke. I agree it's a severe mental health condition, and the ALJ noted that it was a severe condition in her report. What I was saying was that is not a severe mental health condition that is markedly limiting her ability to function in a work environment.
And you could, for example, the ALJ found that her mood reportedly is improved with medication. However, this is at J30 and 739. It cited that the decision only refers to the fact that she was taking medication used. It doesn't say anything about it. It was reported to be improved. Where did that come from?
Well, I believe, as I just stated, there are several sites in the record where plaintiff is reporting that she's doing well on medication. What I think the ALJ is referring to is a treatment note before the onset period with Dr. Luther, where she's saying that her mood did indeed improve with Lexapro.
Well, that's, all right.
And furthermore, on the issue of supportability, as your honors have noted, the ALJ found that there was no way to know if Ms. Sarmati's treatment notes would have supported her opinions because Ms. Sarmati did not submit them to the ALJ. It is true that Ms. Sarmati was not required to submit those notes, but without them, there was no basis to determine whether or not the notes would have been, whether Ms. Sarmati's conclusions were supported by objective medical evidence. Ms. Sarmati's opinions consisted of 2 letters that were dated 10 months apart that were nearly identical and only provided a list of her diagnoses, her symptoms, and triggers, and consisted of a single paragraph that was intended to summarize 6 years of treatment. And only one of those 2 letters was even within the relevant period. Nor does the disability advocate supplied forms that Ms. Sarmati checked boxes on constitute a special report. These forms were filled out in October 2021, which was 10 months after plaintiff's last insured date, and they provide no details as to the consistency, pace, or severity of plaintiff's symptoms over a 5-year treatment period. Nor did Ms. Sarmati clarify how often she saw plaintiff over this time period. Mr. Farrell hypothesized that it could have been up to 150 times. However, Ms. Sarmati did not say how often she actually saw her, only that it was weekly, bi-weekly, or as needed. When Ms. Sarmati was asked to explain her clinical findings and why those merited the limitations she prescribed, she left those sections on the form blank. Given the lack of any explanation or detail, it is no wonder that the ALJ found Ms. Sarmati's opinions lacked supportability. Perhaps recognizing this, at the hearing, plaintiff's advocate stated that he was not asking the ALJ to find Ms. Sarmati's opinions independently persuasive, that is, supported by themselves, but rather supported by the opinions of Dr. McCleary, the one-time consultative examiner. However, the ALJ only found Dr. McCleary's opinions partially persuasive because they were internally inconsistent and, again, unsupported by medical record evidence. And here, plaintiff does not challenge the ALJ's findings as to McCleary, only Sarmati. In any event, the ALJ did not wholly reject Ms. Sarmati's opinions. To the contrary, the ALJ did find that Ms. Sarmati's treatment relationship and some of her clinical findings did support findings of moderate limitations. Taking all this into account, the ALJ was only partially persuaded by Ms. Sarmati's opinion, a finding which was supported by substantial evidence, which is not by itself a high bar. Accordingly, the court asks this court to affirm, the government asks this court to affirm that the district court's decision to uphold the ALJ's finding that plaintiff was not disabled during the relevant period.
And that's based solely on the medication, that it didn't ramp up? Her medication didn't ramp up? I mean, for example, the report from Dr. Sarmati is that she was treated since 2015, right?
Yes, Your Honor.
She has frequent mood, impulse control problems, right? Swings. She's highly excitable, irritable at times, can be easily triggered by environmental stimulations, surroundings, including people, driving and heading traffic. She frequently expressed she's easily triggered by other people and feels unable to control her anger around others. Well, it's a work environment. Don't you have to work with other people?
Yes, Your Honor. And the ALJ did take those opinions into account to some
Very
extent.
little in account, because the diagnosis never changed, did it? Is there anything in this record that she is no longer suffering from bipolar disorder?
There is very little mention in the treatment records as to specifically plaintiff's bipolar disorder. It's mostly as to her depression.
Are you saying that she was not diagnosed with bipolar?
No, Your Honor, I'm
Well, then,
merely,
what I'm asking you, is anything in the record to say that she was cured?
no, Your Honor.
Well then, so these things that Dr. Samardi talked about, they're consistent with that diagnosis, aren't they?
Yes, they are.
Right, so you counted that only because she didn't ramp up with medication?
No, not only that, Your Honor.
What is it that you really based on, you're discounting an undisputed DSM-3 diagnosis that you now, well, you say it is severe. They seem to be consistent, it's been over a long period of time. What is it that discount that the Social Security Commission can say, oh, cheer up, you can work?
Well, Your Honor, bipolar disorder is both bipolar disorder and depression are wide-ranging diagnoses that cover a really wide variety of symptoms and severities.
Understood, that's why we're looking at her. What
Right, so the
doctor
ALJ
said.
was entitled to take a look at the symptoms Ms. Strumgold reported, as well as the longitudinal treatment records of plaintiff's treating physician, Dr. Luther, which shows that during this time period, plaintiff's mental health conditions were very well controlled in that she wasn't reporting that there were any issues coming up with her depression or her bipolar disorder, as opposed to Ms. Sarmati's very conclusory
Where in the record
statements.
does it say that she was no longer suffering from depression?
Not that she was no longer suffering, but
It's
that
not.
it was.
Right, it's not. There isn't. So where are you coming up with that now she's well, and that and this is mild? I'm just trying to, you can't be whole cloth. I mean, in the sense that where is there any evidence that she's no longer suffering from the depression and those symptoms based on the PTSD and the bipolar disorder that she's been treated for since 2015? Where's the evidence that she's well?
Your Honor, no one is saying that she is not suffering from these conditions, only that her symptoms were treated to the extent that she was allowed to work with the very strict work limitations imposed by the ALJ. Notably, the ALJ did not find that she was able to go back to the sort of skilled work that she had been doing before working at Social Security. The restrictions that he put in her RFC take a lot of these limitations into account. In fact, including that she shouldn't be having any interactions with the public and very few interactions with supervisors. So it's not the case that she.
So she has to find a job with no supervisor, not the public. So I guess the usual ticket taker type thing, cashier, wouldn't work that many times that wouldn't work. Well, what would the work be?
Excuse me, Your Honor, let me double check what I believe that's an issue of the vocational expert.
Yes, it would be. I was reading, what would it be? You said, you was ticking off the things that you found this job that exists.
The vocational expert testified that plaintiff would be able to perform a job as a marker.
A marker? What's a marker?
Your Honor, I do not know.
You don't know? And you expect the court to be able to justify a decision about vocational residual ability? That's all I have.
Would you like me to answer that question, Your Honor?
You did answer the question. You don't know. I'm not going to belabor you don't know.
Unless this court has any other questions, the government rests on its briefs.
Judge Richardson. Judge Gregory, do you have
No, I have
further
nothing
questions?
further.
Thank you very much for your argument.
Thank you, Your Honor.
All right, Mr. Farrell.
Hope I have an answer. And I apologize if my argument was not clear. Ms. Drumgold had a prior application for benefits and was denied in that claim. And the time period that my colleague is referring to, during that time, the Lexapro that she's referring to did improve her condition. She then subsequently filed a new claim, and the judge in this claim found that, in fact, her mental health condition had worsened. The criteria of the B criteria of the evaluation of the daily activities and the things she was doing went from, some of the categories went from mild to moderate. And so when you look at Dr. Luther, in response to your question, Judge, during the relevant time, Dr. Luther might have seen my client 6 times, as my colleague mentioned. During that time,
Can I just follow up on Judge Gregory's question? I didn't know what a marker, do you know what a marker is?
I do, Your Honor.
There's a whole, like, regulation about it. Can you just tell me what it is?
A marker is the person who, in the store, I'm not sure this job exists much, but who goes in the store and opens up the case of pumpkin pie filling and stamps each one with the price on it and then puts it on the
Marks and
shelf.
attaches price tickets to articles of merchandise.
Yes.
It goes on and on.
Yes.
And at least the expert here testified that there are 130,000 such jobs that are, that fall within that, like, DOT.
If you exclude some of the
category.
claimant's limitations, yes, no question, there are. What he excluded in his hypothetical was the completing a normal workday, the completing a normal work week, being able to attend and cooperate and interact with everybody at a normal level. The judge did include some interaction limitations in the hypothetical, but the completing a workday, the completing a work week, the regular attendance, which everybody agrees she's going to have problems with, that appears nowhere in the hypothetical. And so what we have...
In the hypothetical, that's what's asked of the vocational expert?
Correct. And then on cross-examination, the representative asked those limitations, and he said, yes, those limitations are work preclusive. So in my view, a treating doctor who sees the client 6 times during the relevant period, mostly for physical problems, is aware of the mental health, doesn't outweigh... I'll take the most conservative interpretation of the mental health professionals' attendance. In the 6 years, if she only saw her once a month, that's 70 times. She knows her intimately. The consultant sees her, and that's his field of expertise, not Dr. Luther. And so when you consider that, I don't think those 6 visits, if I may finish, Your Honor, I don't think that those 6 visits constitute substantial evidence, and I don't think they're consistent with the record as a whole, given that that doctor wasn't treating her for that, other than providing the medications that the therapist and another psychologist verified she needed.
Thank you, counsel.
Thank you.
You don't have any more. You don't have any more. We'll come down and Greek counsel, and then we'll move into our last case. Please be seated. Ms. Albro?
Good morning, Your Honors. May it please the Court. I'm Kimberly Albro here on behalf of the appellant Roe J. Lawson. Mr. Lawson presented 3 sentencing issues in his briefing, and I will discuss those here today. The first one is whether the vulnerable victim enhancement was erroneously applied to him. The second is whether the district court erroneously denied him a minor participant reduction on his guideline range. And the last issue was related to loss calculation. Mr. Lawson's circumstances related to the vulnerable victim enhancement is on all fours with this court's Lamas case. There were 2 requirements set forth in Lamas. One was that the district court must determine the victim was unusually vulnerable in some way. And the second is that the district court must assess whether the defendant knew or should have known of this particular vulnerability identified in the victims. And while I didn't find any case on point in this circuit, the 11th and 8th Circuit, as noted in the briefs on page 17 and 18, have determined that age alone is not a sufficient characteristic to make someone vulnerable.
It would depend on a larger contextual problem. I mean, there could be instances where an elderly person was a victim of a crime and vulnerability wouldn't be at issue. But here there was a good bit of evidence that these individuals who were the recipients of this scam were targeted precisely because they were elderly. And when we're talking about an elderly victim in the particular context of a scam, it would be more likely, would it not, that they were targeted because of their relatively advanced age?
No, I would disagree with that. I think that's exactly what is not allowed under the case law, that just because they are elderly, even in a certain type of criminal behavior, there still has to be an additional vulnerability.
What's the standard of review here?
It's clear error,
Clearly erroneous?
clearly erroneous, because vulnerable victim is considered a factual finding. So what I would say is that while many of the victims that were identified in the record were what is considered elderly, there were others that were younger than what is probably considered elderly. For example, on JA 169, the victims' ages are given, and one was 46, another was 46, one was 61, one was 59. But the point is that there are many elderly people who would not be particularly susceptible to this scam, and that is why the finding is there's a second step pursuant to Lamas.
Counsel, what do we do? I mean, I understand your point, and I understand Judge Wilkins's point that there is some evidence particular to this case. But what do we do with all of the work that is done by Congress and the Sentencing Commission that says that age is a vulnerability, right? I mean, we go through, over the last couple of years, there's like a Stop Senior Scams Act, right? There's like a World Elder Abuse Awareness Day. There's the Senior Safe Act from 2018. There's the Elder Abuse Prevention and Prosecution Act. All of these things include these findings that the elderly are susceptible to being defrauded, right? And then the Sentencing Commission recently does a revision of its guidelines, totally appropriately, it seems like to me, to say, well, particularly young people, we ought to pay particular attention to whether that's mitigating for them, just based on the age and the recognition that, you know, an 18-year-old's noggin doesn't work quite as well as somebody that's a little bit older, right? That seems like a totally reasonable judgment for the Sentencing Commission to make, and they've done so. But why do we sort of ignore the reality, it seems like to me, that at least Congress and the Sentencing Commission, and I don't think they're alone in this, sort of recognize the reality that those that are elderly are disproportionately vulnerable to being defrauded in schemes exactly like your client has designed and targeted?
Well, I would disagree. I just want to make it clear, I don't think he designed this scheme. That's part of the argument later, so I don't want to leave that on the record. But it is true that there are places in the guidelines and in the law where age is a factor. Certainly, Miller versus Alabama is about whether a youth can be sentenced to death or sentenced to life without
But
parole.
as Judge Richardson pointed out, I mean, it's a matter of very common knowledge that elderly persons, they're likely to live alone, more likely than not to live alone. Their spouse is often have passed away, dead. They are often victims of cognitive decline. and many cases lack the stamina and acuity to resist these kinds of scams. And in addition to the voluminous evidence to which Judge Richardson, I think, rightly points, the vulnerable victim enhancement provision in the sentencing guidelines mentions elderly persons. And they were targeted because they were elderly, and the indictment to which he pled, and the count 1 of the indictment says he contacted elderly persons with requests for bogus fees and taxes, and then you get down to the plea colloquy, and the prosecution reads the different elements of the offense, and one of those is the elderliness of the victims, and then the factual basis of the plea is supplied when the individual says, he says, do you agree? And he says, I agree to this. So you have the indictment and you have the plea colloquy that says they've been targeting elderly people, and you have elderliness and age mentioned in the sentencing guidelines provision as one of those things that was a characteristic of a vulnerable victim. And here we're up here under a clearly erroneous standard on what seems to me to be a factual finding on an enhancement that we accord a degree of deference to district judges. How can we say that people who are targeted because of their age, and how can we say that they're not vulnerable? I mean, it's a conclusion that just won't stand up in the eyes of Congress, and it won't stand up in what people understand are the natural infirmities that come with advancing age.
Well, Your Honor, again, age is not the sole factor. There is an aspect of vulnerability. Mr. Lawson does not dispute that he was aware that some of these people that were called were elderly. He said that he was aware when the callers made the calls, he knew.
It was, again, as a factual matter, one of the reasons that these folks were targeted, because it was more likely that they were going to be susceptible to this kind of fraud. And, you know, the nub of it is here that you've got people in an advancing state of frailty that are, with full awareness, the target of a fraudulent scheme to swindle them out of what may be limited funds. And the fact that they were elderly made them a far more attractive target for what this individual was, these people were trying to do. And we're going to say that a district court was clearly erroneous in taking that into account?
The only vulnerability offered at the district court was that one person had Alzheimer's, and that was discovered by the postal inspector in a police report in Washington State. So there is no evidence whatsoever that Mr. Lawson knew about this particular person's vulnerability. And then in passing, one man might have had dementia. The point is that age alone isn't enough. There has to be some other vulnerability, and there has to be a showing.
It's not just age alone. I grant you there are plenty of situations where someone who, you know, may be the victim of a crime, and they could be, you know, by some kind of happenstance, or it could be that there was a encounter in a street or whatever. I don't know, but But here, it seems to me, where you're talking about a scam, and you're talking about fraud, and you're talking about phone calls and the rest, it is exactly the type of activity that is likely to prey successfully in this case, because they reaped to $720,000 from these people. And so when you put age in context with a scam that looks upon vulnerability as, looks upon age as something that increases the probabilities of susceptibility to this kind of fraud, when you put it in the context, and then you're saying that are we saying the district court was clearly erroneous in applying the enhancement? I don't get it.
The fact that if age alone is sufficient to show the vulnerable victim enhancement in this type of fraud scheme, there would be no reason to have the additional vulnerable victim enhancement, because the assumption would already be made regardless of the specific
But the
facts
thing
of
is,
this
but
case.
from your standpoint, this thing is made all the worse by these, I guess the term is reloading. And what I would say is, reloading means multiple calls. And so you have many elderly persons that were preyed upon not once, but repeatedly. And we're supposed to say, that, oh, it's no problem, they're not vulnerable.
Well, again, I don't know I don't think there's anything in the record that says that my client was aware that he received money from the same people or that the reloading was going on. And Lamas specifically addressed that issue where reloading was never brought up at the district court in Lamas or here in this case. And the Lamas court still sent the case back to the district court because there was no presentation of the reloading issue. The first time that has come up is in the government's brief on appeal. The second issue is the minor participant, and I'm getting low on time, so I'll briefly address that. Mr. Lawson argued that he should be a minor participant, and the district court denied that. The main issue is that the analysis was focused on something that the Sentencing Commission has explicitly said does not preclude a person from getting the minor participant reduction, and that is that the person was essential to the scheme. There are factors in the guideline. The district court did not address those factors that are in the guideline. And when probation responded to Mr. Lawson's objection, even though they noted those factors, most of what probation focused on was that.
Wasn't there a finding here that Mr. Lawson played a critical role in collecting, moving, and laundering the proceeds of the fraudulent activity, and that he was involved in as a part of the laundering scheme and transferring funds to Jamaica to an account that he had opened? I mean, he was, in terms of the handling of the funds, he was quite an instrumental agent. He wasn't a minor player.
I'm about to run out of time if I'm allowed to respond.
Those are findings.
The court said that he had equal engagement with his co-defendant as the organizer of receiving funds, and that is not looking at the broad context of all the co-conspirators. And I see I'm out of time.
Hold on a minute and let me ask the Judge. All right, thank you very much.
Thank you.
All right. Let's hear from Ms. Hoffman. Be happy to hear from you.
Thank you, sir. May it please the court. Andrea Hoffman, on behalf of the U.S. Attorney's Office. Your Honors, as Judge Wilkinson and Judge Richardson were discussing, the vulnerable victim enhancement in this case was properly applied. This court's case law in Sterling, U.S. versus Sterling, U.S. versus Shepard, in Stencil, all establish that there is a strong inference when victims are elderly. They're specifically targeted for being elderly. And that, as Judge Wilkinson was recognizing, these are often persons who are isolated in their homes. The fraudsters reach into their home and persuade them and induce them to give away assets that they can rarely afford to give away. The court in both Sterling and in Stencil has said that there can be a strong inference that they are targeted specifically because of their vulnerability, and that the nature of the kind of fraudulent activity involved. In Sterling, for example, it was specifically the same kind of Jamaican lottery scam, that these types of frauds in and of themselves are targeting elderly people for their age-related infirmities and seeking to capitalize on the kinds of things that happen.
They're vulnerable from a variety of perspectives. Number one is cognitive decline. Number two is they live alone in many instances because their spouse has passed away. And the third thing is they very often have limited means. And many of them are living off of Social Security, and that's about it. And they're being preyed upon with all these recognized general infirmities. They're paid upon to depart with what are often, not in every case, but that's not the question, what are often very limited means, and they are preyed upon by fraudsters to take the limited funds that they may still possess. And it just as a humanitarian matter, preying upon these kind of people, it seems to me, is exactly the kind of thing that Congress and the Sentencing Commission had in mind for this enhancement.
I would completely agree, Your Honor, and the district court was equally offended by it. It called it a heinous crime and was disturbed about the targeting of the vulnerable stage of these victims when it made its finding at page 86 in the joint appendix. The court was completely persuaded this defendant knew exactly what they were doing, that they were targeting the schemes for the reasons the court referenced earlier about the indictment, the elements of the offense, the factual proffer.
It doesn't mean that every elderly person who is a victim of some kind of crime is automatically entitled to the enhancement. That's a more absolute position. I wouldn't go that far. I don't think our precedent allows it. But when you take it in the context of this kind of scam and the vulnerability, for obvious reasons, of elderly persons to this kind of misconduct, it's the context, it seems to me, that matters.
I agree completely, Your Honor. 80 of the 179 victims were over 70 years old. It was clearly the context and the targeting they were doing. If there are no other questions about the vulnerable victim issue, I'll move on to the minor role that counsel discussed. The district court was...
Can you start on the minor role participant by telling me how I ought to think about defining the scope of sort of conspiratorial conduct? It always strikes me as a hard question, and I take your colleague's argument to fundamentally be, you can't just look at these two defendants. You've got to look at the Jamaican lottery scam as a whole, right? Everybody that's involved in it. In the drug conspiracy context, the similar argument is made that, like, my guy was, yes, distributing large quantities of cocaine, but when you consider the chain from the farmer in Colombia all the way to the distribution in Colombia, South Carolina, that being, and you consider the whole enterprise, my, kilo level dealing is really a minor role. How do I think about that? How do I draw those lines? Do you have views on how we ought to think about the Jamaican lottery scam as a whole, right? Everybody that's involved in the same basic scam? Or is there some way to draw lines there?
There are ways that the court could choose to draw lines, Your Honor. I think in this context, the district court did consider the entirety of the scam, so you can look at it in that way. One of the lines that you could consider drawing is that he was held responsible for the losses that came through he and his mother, not all the losses that came through every phone call and every scammer and every person that was moving money for this organization. So because he was held accountable for losses that were limited, relatively. Even in his own circumstance, he wasn't held accountable for every kind of loss that could have been held to he and his mother.
So in
You
other
could
words,
look at it smaller that way if you wanted to.
one way to think about it is to use the sort of loss amount, or in the drug context, the drug quantity, as a way of sort of defining the scope of this sort of criminal organization or enterprise?
You could, Your Honor, if, just to give a concrete example, if there were $1 million worth of money moved and this defendant only was responsible for moving 400,000 of it, and he was held to a loss amount in a sentencing guideline range that's the 400,000, well, he's not a minor role player in moving that 400,000. He's a key player. Frankly, as Judge Wilkinson said, he was a key player no matter what, because he was autonomous. He was organizing the bank accounts. He was making the determinations for whether to send the money from a bank account or a wire transfer, which kind of wire transfer, and that's the larger.
The thing here, it's a good point that my colleague makes, but he was found to play a critical role in all the aspects of it, in the collecting of the funds, in moving the funds around, in concealing with them, and it's a chain of events that one cannot be easily separated from another. The conspiracy as a whole depends upon the success of each link and each part, and this individual was up to his eyeballs in not just one aspect of the conspiracy, but in all the links of it. But again, this is a clearly erroneous standard of review. It's hard to reverse Judge Hendricks' committing clear error when somebody is actively and prominently engaged in maneuvering funds around, and not just in maneuvering funds, but collecting the money too.
To the court's point about collecting, one of the things I would emphasize for you is this defendant pled guilty to 8 counts involving reloaded victims. If you look at pages 148 through 149 of the PSR, to which there were no specific objections lodged to those paragraphs, 8 of the counts that he pled to involved reloading of victims. So it's, again, receiving money from multiple places that are targeted in to operate this scheme to the vulnerable victim status. This defendant's fingers were all over it, including recruiting people. There's no circumstance in which you could say that this defendant was of substantially less involved and less culpable than the majority of the persons involved in the operation. And so the minor role calculation should be affirmed. If there are no other questions from the court,
I have a question, Ms. Hall.
Yes, sir.
That is, he was enhanced at 14 levels because of, in terms of loss here. But it seemed that, help me with this, it seemed like it's a question about intended loss versus actual loss. Because the district court asked the question, he said, I think he says, the intended loss is $720,948. Is that right? And the probation officer said, yes. But in other parts of the record, they said that $720,948 was the intended loss, and in another place, it says he's responsible for the same amount, exact amount for actual losses. And that makes a difference here, doesn't it? Because under the guidelines, you have to weigh the greater of those two. But here, it seems like the record is some confusion. Doesn't that require remand for that aspect of the sentencing procedural error?
It does not for several reasons, Your Honor.
All right.
First is that the defendant never raised this objection.
That's right, but that's
He
why
never-
we can review it at a different level, right?
Correct, Your Honor.
Plain, that's right.
So setting now aside the question of whether plain error or otherwise.
But it
there-
is very important that you sentence correctly, right? That's the biggest part of the whole thing is sentencing.
Absolutely.
Right, go ahead.
Now, it's also not an error, Your Honor. It is an inadvertent excuse me, stumbling over my own tongue, apropos in this moment. It's loose language by the court. The actual.
Loose language by the court, that was a response from the probation, right? The judge asked the question, is it that? And the answer was yes. Am I wrong about that?
You are correct, Your Honor. The court.
JA 101.
You are absolutely correct. Both the
Okay.
court and the probation office used the term intended at some point. If you look to exhibit pages 168 through 172, which is attachment A to the PSR, this is the manner in which the actual loss amount was calculated. The figures are there. On the last page, on page 172, it demonstrates that the actual loss was, that the loss figure was actual losses. If you look more even basically at the actual math that was used to determine losses on this category, there's $405,401 in losses that are known losses to known victims. There's also $315,547 in known losses to not fully identified victims. Those actual losses are the basis by which the court sentenced this defendant.
Now, how do we know that the actual losses to people you don't know about? Tell me.
If you look at page 172 specifically, I didn't bring it up, but I can.
I might try
Go
to
ahead.
show a summary of it. You tell me.
There's a third category of victims in that chart, Your Honor. There are persons who are fully identified for whom no losses can be specifically identified.
Right.
So there's a third category. If the court had attributed a loss figure to that category of persons, we'd have intended loss. We'd have, if it had made an estimate of.
But it didn't. But
It didn't.
tell me about these people. Those are the people you're talking about. You can't identify them, but you attribute an actual loss to them?
There are persons where they can they've traced out 720,000 and change in losses. They can track that, the course of those
And how was
losses.
that traced without a person being identified as giving up the money?
You're tracing the monies as they are coming into the accounts for Roger Lawson and his mother, specifically, because they did, back to Judge Richardson's point, they did limit the loss calculations to the parties that were involved in this case, not everything that might have come out of this Jamaican scheme. And so across the breadth of all of the various accounts that they were using and the money transfers that they could identify, these are the losses that they could come up. And the government specifically took a conservative approach to it and asked the court to do so as well, which the court did do.
So there was no intended loss calculation in this case?
Correct.
But he certainly mentioned it many times in the record.
It does, Your Honor, but because the
So
math
how is
is.
the court going to just disregard that? With all due respect to you as counsel, I know you're worthy and trustworthy counsel, but we just can't just do that in terms of record, do we? We don't normally do that. We say the record evidence is the record evidence.
Well, two things, again, Your Honor.
Okay.
One, the court is entitled to, district court, was entitled to sentence on the greater of intended versus actual loss. So, and intended loss, virtually always, I can't think of a hypothetical in which intended loss wouldn't include actual losses.
Right,
If they
that's
had
where I thought you were gonna go, right?
Wait a minute. You can't think of a way intended loss wouldn't include actual?
Assuming that,
Absolutely. You could call a person up and try to make a mark for 5 months and never get any money. And you intended, but it's not actual.
sir, I didn't get the sentence all the way finished, and I apologize.
About to say it.
By what I meant is, when there have been ascertainable losses, and there have been efforts to obtain even greater losses, that actual amount of loss will always be part of the intended loss calculation.
The one, how you ascertained that was that's money flowing into an account solely by deposits. That's right, that's what you told me, right? Because that's the kind of money that came through. How do you know all of that was based on this activity?
Well,
So that's different. I mean, you know, like you had to watch figures in this, because I heard exactly what you said. You said we calculate that based on what came into their account. That's not attributed to any individual. You're just saying, well, everything you put in this account had to have come from a victim, right? Isn't that the math logic to that? Arithmetic logic to that?
That is the arithmetic logic to
That's
that,
what I
Your Honor,
thought.
is that the fraudulent bank accounts that this defendant admitted creating in the indictment and to his plea colloquy were the sources for which the government presented lost figures to the probation office and the court. That's based on the defendant's admissions of what they were doing and the defendant's admissions of that the accounts that we had identified were fraudulently being used. And those are why we had forfeiture
But
provisions,
the
for
whole
example.
loss calculation here was based upon actual loss.
Yes,
Intended loss was simply a subcategory of an actual loss. And in terms of a sentencing, which, once again, I can't remember situation where we reversed a district court on a calculation of a loss amount. If you intend the loss, that should factor into sentencing.
I would agree, Your Honor.
But it's very important because, I mean, that's the calculus for mass incarceration. This is very important. These numbers, 14 level increase, was it not?
Yes, Your Honor,
So
and that
this-
was a conservative number for this defendant.
Right, okay, well, it's conservative or not, that's time you gotta spend in prison. I mean, so these aren't just numbers. Maybe we should reverse in some cases when it's wrong. I mean, then, we're not just talking about bean counting, we're talking about these counts. This counting equates to time in prison. So I can't think of anything of our Constitution, our framers, would think that something like this is not just pedestrian. It's the sine qua non of your terms you spend in prison.
Your Honor, I would not be at all treating this in any manner that might be considered disrespectful. The district court itself said this was a heinous crime and that this defendant, albeit
Well,
can't...
sure, it's a heinous crime. That's why, he was punished. He's punished. This is additional aspect of it, and here we do use numbers. I mean, would you agree, no matter how heinous this is, if there was no loss, you couldn't elevate the 14th level, right? You agree?
No, I wouldn't, Your Honor, because intended loss,
No,
if they had been unsuccessful in ever obtaining money,
okay, let's say that.
but intended loss would still give us a loss
Different
figure.
hypothetical. Let's say if the loss was only $10,000. Could you go to 14, no matter how heinous this is?
No, Your Honor, but it
No, you couldn't.
probably wouldn't be heinous the same way when you have 180 victims versus 10.
You don't know that. I mean, people sentence it, I mean, you're saying that I've seen sentences based on a lot of things about people and who's being charged and how much being charged has a big factor in terms of how much time they get. So I don't know whether that's true or not. But I do know that the 14th level was based on these numbers, and they're important. And we say in the record it's there, but we can just ignore it because it was heinous. That's the...
I'm not asking the court to ignore anything, Your Honor. I'm simply asking you to rely on basic math and the...
It's not basic math, it's just inconsistency in this record. Do you agree with that? Do you agree that it's inconsistent in terms of these terms being used?
I would agree that they're interchangeably used, Your Honor. Actual and intended term, the term intended and
No,
actual are interchangeably used.
this thing is up here on plain error, I think.
It is.
Wasn't even emphasized in the oral argument here, but there's nothing wrong with basing a sentence and calculating a loss amount on the basis of what is an intended actual loss. I mean, that is the intended loss goes to the culpability of the crime. It's a mens rea factor. It goes to knowledge. It goes squarely to mens rea. And, that's one of the things that you sentence upon. It's one of the things in which guilt or innocence is I don't see any injustice in saying if somebody, if somebody finds if a district court finds as a fact that someone intended a loss of a certain amount, to me, that's a culpability factor, that's a mens rea factor, that's a knowledgeable, that's a knowing and intelligent factor. And it doesn't seem to me wrong in any way, and much less clearly erroneous or plain error, to have that kind of factor which is intimately intertwined with culpability. If you plan to defraud somebody of a dollar and through some accident the individual is not identified, it doesn't have anything to do with the fact that you intended that loss of a certain amount.
I would completely agree, Your Honor. I do see that my time is up.
But counsel, didn't you say that there was no intended loss in this case? That's what you told me. That's what you told me. You said it's all actual. Did you not? Am I misinformed?
What I said, Your Honor, is that the actual loss that they attributed to him was actual loss.
And you said, didn't you say there was no intended loss?
I'm not trying to say that there was no intended loss, Your Honor, because there are, as I noted,
In this
there are,
record, what part was the intended loss?
there are identified victims that there is not an identified loss. That could have been included.
But it could
It
have
was
been. I'm
not.
not asking what could have been. The question is, there is no intended loss in this case. Is that right?
In the manner that you're talking, yes, Your Honor, that is correct.
In the matter of this record. Is that
Why
right?
would you say that?
There's,
Right, that doesn't seem, I don't understand why you're saying that at all, right? Because there's no reason to think that the $720,000 was accidentally lost, right? He was part of a group that intended to take that from people. And it is both actual and intended. We could have a case where you got more money than you tried to get. All right, that's some accident, right? The teller keys in the wrong number. Then the actual loss would not match the intended loss. But everything here suggests that the amount of money they got is exactly what they intended to get. At least what they intended to get.
at least is the right phrase, Your Honor. It is at least what they intended to get. There are victims for whom we couldn't attribute a loss.
So stick to your guns, don't get twisted around on that.
I
This is a-
apologize, Your Honor.
You got good counsel here to help you here.
They-
But still, the record is the record. That's all I have. Thank you.
Thank you, Your Honors. I ask you that you affirm.
Judge,
I have nothing.
Just briefly, Your Honors, I did not get to the loss amount in my opening, but what I would say is that intended versus actual, as far as how I tried to present it in the brief, is related to the guideline where one or the other is used. And I think that.
But is there, just to ask Judge, what I think is Judge Gregory's question, is there any reason to think that the actual loss in this case was not intended by your clients? Your client and his mother?
I don't,
I mean, that seems like what his confession was, right? He confessed, this is what we were trying to do.
well, they received the money that was solicited by their co-conspirators in Jamaica, so whatever came to them is what they expected to get. The question with the interchangeable use of intended and actual is just a matter of confusion, and I think that the Sixth Circuit case of Warshak that was cited in the brief gives a good example of why I raised that issue. It's just that it's hard to determine. I'm not even sure, since the district court asked the probation officer, what is the intended loss, when it appears on the chart that the government referenced and that was attached to the PSR seemed to be actual
I don't
loss.
think that there's an infirmity here, particularly with regard to the amount. The only infirmity is that the victim, the particular victim, may not have been identified, right?
No, that's not the issue, Your Honor, as far as from my client's perspective, because he also raised an issue related to the dates, and he never got an updated chart with the dates. He had no way of figuring out whether this unassigned amount that's on the chart attached to the PSR that was lumped as actual
But the
loss,
amount of
whether that
intended-
was double
The amount of
counting.
intended loss is, again, the amount of the intended loss is a question of fact. And that's subject to a clearly erroneous standard, and it's up here on plain error, for goodness sake. And I think this whole idea of whitewashing somebody and because they only intended the loss, that
You know, the issue about intended and actual loss is not necessarily just about the factual aspect of how much it is. It's a matter of the guideline requires that one or the other be used, and the district court did not seem to make the record clear or make a finding as to what she used to enhance Mr. Lawson's sentence by the 14 levels.
Right, that's clear in the record, did not. Go ahead.
And I also would say that during the government's presentation, it was referenced that related to the minimal participant, that my client was found to have participated in every aspect of the scheme, and that's incorrect. Even the government's presentation at the change of plea colloquy on JA 5556, they referenced that the Lawsons were involved in soliciting money, or that their co-conspirators were involved in soliciting the money and directing it to the Lawsons. So the actual contacting of victims, the soliciting of the money was done by the co-conspirators, which is why Mr. Lawson argues that his minor participant argument should have been considered in light of all the people in the conspiracy. The government brief reiterates those facts. It says that the victim sent money to the Lawsons, the Lawsons received the money, and then they were told to send it to Jamaica. So they were directed what to do with it. Mr. Lawson essentially is like a low-level drug courier who received, I think Teresa Lawson might have been the one that said it, she received 10 to 20% of all the funds that were taken in. Everything else went to many, many co-conspirators in Jamaica. Page 32 of the government's brief talks about this larger conspiracy in Jamaica. I believe that in the record there are articles talking about these Jamaican sweepstakes schemes, and they are very large, involve a lot of people. The government's supplemental joint appendix has charts where Teresa Lawson was sending money. There are numerous other people besides Teresa and Mr. Lawson listed on that. So I would just ask that the court consider these arguments, and I will rest on the brief because I'm out of time.
we thank you very much, and we will adjourn court and come down and greet counsel.
This honorable court stands adjourned until tomorrow morning. God save the United States and this honorable court.